Locking away a cola recipe or a blend of herbs and spices in a vault are extreme examples of how companies safeguard trade secrets. In Learning Curve Toys Incorporated versus PlayWood Toys Incorporated, we'll see whether a company's toy design was a trade secret that a competitor couldn't reproduce. Robert Clausi and Scott Moore owned PlayWood Toys, a small toy company. At a toy convention, PlayWood met with representatives from Learning Curve Toys, a large toy company. Learning Curve proposed that PlayWood could potentially make toys for Learning Curve. At a later meeting, Learning Curve told PlayWood that it would disclose new designs to PlayWood. PlayWood agreed to keep the discussions confidential. PlayWood also told Learning Curve that it would share confidential ideas. Learning Curve lamented that it couldn't create a successful toy train track. Clausi shared his idea to create grooves in a track which would mimic the sound of a real train when a toy train went over the track. Learning Curve acknowledged the new track design was a novel concept. Clausi told Learning Curve that PlayWood would name the track Clickety Clack Track. PlayWood gave Learning Curve a sample of a grooved track. Ultimately, PlayWood didn't receive a contract from Learning Curve. However, PlayWood later discovered that Learning Curve was selling a grooved track named Clickety Clack Track. Since it first started selling Clickety Clack Track, Learning Curve made over $20 million. PlayWood sent a cease and desist letter to Learning Curve. Learning Curve responded and sought a declaratory judgment that it owned the noise-generating track concept. PlayWood counterclaimed that Learning Curve misappropriated PlayWood's trade secret. At trial, the jury found in favor of PlayWood. However, the district court declined to enter judgment on the verdict and found in favor of Learning Curve. The court held that PlayWood didn't present sufficient evidence that its noise-generating track was a protectable trade secret. PlayWood appealed.